From a woman caught breaking into homes and stealing.
You are charged with the offense of home invasion in the third degree. That's a felony punishable by up to 5 years incarceration, a $2,000 fine plus court costs. That is alleged to have occurred on January 6, 2025 at the location of 508 South Division Street in the city of Ann Arbor. Do you understand the nature of those charges, or that charge, and the maximum penalty?
Yes, Your Honor.
To another pleading guilty to fentanyl possession.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
I understand that.
All right. And understanding that, you still wish to plead guilty?
I do wish to plead guilty.
These cases expose just how Judge Simpson ensures repeat offenders are held accountable. Starting with Ms. Warren, a woman accused of not one, but 3 separate home invasions. This woman's audacity and pure disregard for the law is pathetic. Let's watch this.
You are before the court on 3 other charges, or 3 other files. All right. Let me just go through a brief arraignment with you on that. In the case ending in 5522, you are charged with the offense of home invasion in the third degree. That's a felony punishable by up to 5 years incarceration, a $2,000 fine plus court costs. That is alleged to have occurred on January 6, 2025 at the location of 508 South Division Street in the city of Ann Arbor. Do you understand the nature of those charges, or that charge, and the maximum penalty?
Yes, Your Honor.
All right. In the case ending in 5517, you are before the court on a complaint that alleges that on or about January 13, 2025, at the location of 336 South State Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did commit the offense of stealing or retaining without consent a financial transaction device. Do you understand the nature of that or that charge, ma'am?
Yes, Your Honor.
That's a felony punishable by up to 4 years incarceration and a $5,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
In the file ending in 5516, you are before the court on an offense that is alleged to have occurred on January 10th, 2025 at the location of 350 Thompson Street in the city of Ann Arbor, Washtenaw County, state of Michigan. That offense being home invasion in the second degree. Do you understand the nature of that charge, ma'am?
Yes, Your Honor.
That is a felony punishable by up to 15 years and a $3,000 fine plus court costs. Do you understand all of that, ma'am?
Yes, Your Honor.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, Your Honor.
These are public defender cases.
Hannah Mackey on behalf of Ms.
You waive for further formal reading.
We do, Your Honor.
And how does your client plead?
Not guilty, Your Honor.
Defendant having waived formal reading, pleading not guilty, court will enter that not guilty plea. Demanding a preliminary examination, I will set this for probable cause. I will set. Are you looking for an adjournment?
We are.
I'm looking for an adjournment to
waive timelines.
Yes, we do.
I will set a probable cause conference in these matters, adjourning the one and setting the other one for March 6, 2025, 9 a.m. And at that time, we'll set a preliminary examination when the case is ready. Anything else to bond?
No, Your Honor.
None for us, Your Honor.
Bond in these cases will be set in the amount of a $10,000 personal recognizance bond, all other standard conditions, including no assault behavior or possession of weapons. She's not to possess or consume any alcohol, recreational marijuana, or any illegal drug. With respect to, I'm also going to enter that she is not to go to the stated addresses in the one case of 508 South Division in the city of Ann Arbor. And in the other case, the State Street address.
In Your Honor, there's a co-defendant. He's currently in the jail, so it's not. I'm not terribly concerned, but I would ask for a no contact with the co-defendant, Cedric Green.
Cedric Green,
Yes.
you, any response to that?
And we represent Cedric currently. If he's the co-defendant.
You,
Yeah. He
had
was
the-
up for prelim on Tuesday, and we had to adjourn it. But yes, your office, Miss Pate, I believe, was representing him on Tuesday.
got it.
I believe there may be a conflict.
You think? All right. So I think his name was with an E at the end.
I think it's SEA. Oh, yes, you're correct.
All right.
His first name.
What I will do is I will order no contact with Cedric Green on all of these matters also. All
Yes,
right.
Your Honor.
Okay. All right. This one is self-vision. The other one, I just need it from the complaint
Okay, and I'll confirm.
on here.
I'll confirm this.
This time we have Mr. Dante, who still thinks he deserves a bond reduction after racking up multiple criminal convictions.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Powell.
Your name?
Deontay Paul.
All right. What are we doing?
Your Honor, we're requesting an exam date. I have all discovery.
People have their witnesses available on the 25th.
I'm not available on the 25th unless it's in the afternoon, Judge.
Now, you know, you've been here. You said everything in the morning.
Okay.
So would the March 4th work then?
I have a jury trial that starts March 3rd. I have a jury trial that starts March 10th for the same individual. He has similar type cases. I did put in my calendar that I was available March 18th.
March 18th? All right. Any objection from the people on that day?
Thank you.
Preliminary examination in person. We set March 18th, 2025, 9 a.m. That is before Judge Barr.
You said Barn?
Barr. Barr.
Okay, thank you, Judge. My client does want me to address the current bond.
Okay. Go ahead.
Judge, we were asking for a 10% option. I believe that the court has cash or surety, no 10% option. My client's mom is here and other members of his family, Judge. He will be with his mom, Judge. I know that I anticipate that the prosecutor is going to talk about perhaps a prior case, but I don't believe he'll be in contact with a complaining witness. Thank you.
Yeah. Response.
Your Honor, I do object to any change in the bond. Should have counted these up, but there are almost countless prior domestic violence charges, many of which were dismissed, but some of which resulted in conviction. I appear to have been dismissed previously, to say nothing of other charges that are domestic violence adjacent that were also dismissed to include charges, things along those lines. Judge, I'll leave it at that. He's facing 2 felonies. He's obviously, in addition to all the DV counts that have previously been dismissed, at least 2 that he's convicted of giving rise to this felony. I'm unaware of any change in circumstances that would warrant any change in the bond. Stay as said.
At the time of this,
Respond. That's what we don't want to. You'll see. You're not getting it.
he's got holds out of other courts, is what I see. He's got over 10 prior criminal convictions, 3 violent felony convictions, and 1 drug conviction amongst that. The other thing is, does he have an active PPO out of 22nd Circuit?
I'm not aware of
Or
that,
this.
Judge. I don't know. The prosecutor might know.
That's the information that I have before me. But taking all of that into consideration, the motion for bond reduction in this case is denied. The court believes the bond is set as appropriate. Bond will continue.
Thank you, Judge.
Now it's Mr. Bohr facing charges for trying to resist police arrest and also using spray, and it's even crazy how it wasn't used out of self-defense.
Court does call the case of the people versus John Boyer. 2 cases.
Good morning, Your Honor. Ashley Lonnie for the people of both matters.
Good morning, Your Honor. Good to see you. Robert Ellman on behalf of Mr. Boyer in both matters. Mr. Boyer, can you please state your name for the record, Mr. Boyer?
John Michael Boyer.
All right. I have 2 resolution or 2 plea forms.
That's correct, Your Honor. In the case 24F31637FY, the defendant is going to be pleading no contest to an added count 2 of attempted resisting or obstructing a police officer, a 1-year misdemeanor and or $1,000 fine. In exchange for that plea, count 1, fleeing and eluding in the 3rd degree, the 5-year felony will be dismissed. Defendant must enter into 15th District Court's mental health court. I understand he's already been accepted. In the other file, 23F0062FY, the defendant is going to be pleading to an added count 3 of attempt use of self-defense spray, the 1-year misdemeanor, contrary to 750224D. In exchange for that, counts 1 and 2, both FA will be dismissed, contrary to 75082. In that file, the defendant must also enter into a complete mental health treatment court.
And that is my understanding of the agreement as well, Your Honor. And I believe these will be no contest pleas, and you should have both reports in your file there.
You and I have looked at them. So, all right. May I have him sworn?
Raise your right hand. Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got?
Yes, sir.
State your name.
John Michael Boyer.
All right. Mr. Boyer, it's this court's understanding that you are going to be pleading no contest to 2 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
The first charge is that of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
The other charge is the offense of attempted use of a self-defense spray. That is also a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court.
Yes, Your Honor.
Basis for the no contest, please.
Potential civil liability, Your Honor.
All right. Sir, to the charge of attempted resisting and obstructing, how do you plead?
No contest.
To the charge of attempted use of a self-defense spray, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal over it.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
Court has been provided 2 police reports. First, in the case ending in 1637, the court has been provided and has reviewed Chelsea Police Department report for their case number 244277. And in the other matter, Court has been provided Chelsea PD report for their case number 24240. Any objection to the court having reviewed those reports?
No, Your Honor.
No, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
The court will accept the defendant's plea in case ending in 1637. Count 2, count 1 is dismissed. In the other matter, the court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and reports are ordered at 1483 probation. Sentencing in these cases will be March 10th, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor. May we address bond very briefly?
Very briefly.
Your Honor, Mr. Boyer has been in custody most recently since right before Christmas. I don't believe his mother is here today, but she's been here in the past. He does live with his mother at home. She's assured me that she will make sure that he does everything he needs to do. I think possibly a release on a GPS tether could be appropriate in this matter, given the resolution.
He's going into the mental health court.
Yes, Your
Is
Honor.
that correct?
That's correct, Your Honor. And in the older file, which is the file that just led to the use of self-defense spray, he was gone on bench for several months. So I'm actually opposed to any change in his bond at this time. If the mental health treatment court decides that he's eligible and good for release, I wouldn't have a problem with Mr. Ellman contacting Judge Freshour's court and the APA assigned there to arrange that. But at this time, I'm going to oppose any change in bond.
All right. I would have to agree with that. I think I'll let the mental health court make the determination as to release and under what conditions. So motion for bond reduction at this time is denied.
Thank you, Your Honor.
This time, we have Christopher Kaka, who got caught recklessly driving and illegally carrying narcotics. Let's watch how the judge handles this.
All right, we're here. I have this is unit manager help. I have Mr. Kukula here for you, sir.
All righty, thank you.
And Your Honor, it's my understanding there's going to be a plea today. I don't believe the box was checked. I apologize for that. It's going to be a guilty plea. And my understanding of the offer is that count 1 will be amended to a use. He'd be pleading as charged to count 2, the reckless, and count 3, the DWLS, would be dismissed.
So he's going to be pleading guilty to the charge of reckless driving, the stated count, the added count 4 of use of a Schedule 1 narcotic, a 1-year offense. Upon his successful plea, that those charges, counts 1 and 3, would be dismissed.
That's my understanding of the offer. Mr. Kukala, did you hear that?
Yes, sir.
Is that your understanding of the offer as well?
Yes, it is. Absolutely.
All right. Mr. Kukala, I'm going to have to ask you to speak up a little bit for me, okay?
Yes, sir.
All right, thank you. All right. And there's no objection from either side to the defendant taking this plea via phone?
No, Your Honor. I can recognize his voice from our prior conversation.
All right, very good. Why are you moving furniture? Never mind. We'll talk in a minute. Mr. Kukala, can you raise your right hand?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
All right. State your name for the record, please, sir.
My name is Christopher Nicholas Kukula.
All right. Sir, it is this court's understanding that you are going to plead guilty to 2 misdemeanor charges. Is that your understanding?
Yes, sir, it is.
All right. First of all, that you're going to be pleading guilty to the charge of reckless driving. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
The other charge is an added count 4 of use of a Schedule 1 narcotic. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, Your Honor.
All right. Understanding all of that, do you still wish to plead guilty?
I do.
To the charge of reckless driving, how do you plead?
Guilty.
To the charge of use of a Schedule I narcotic, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, I do.
All right. You gave permission or did sign an advice of rights form, is that correct?
Yes, Your Honor.
All right. You have any questions regarding any of the rights that were explained to you?
I do not.
You understand, sir, that by entering this plea, you're waiving all of your trial rights?
I do. Yes, sir.
All right. You understand also, sir, you're giving up your right to appeal of right.
I do. Yes, Your Honor.
Are you on probation or parole? You are not.
I am not. I'm currently incarcerated in the Federal Bureau of Prisons.
Thank you, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
Absolutely not.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes,
And because you believe that you're guilty of these offenses?
that's correct.
December 24, 2020, at the location of Michigan Avenue near I-94, Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Did you operate, how were you operating that motor vehicle that makes you think that you were driving recklessly, sir?
I believe the conditions of the road, it was winter time, and I was speeding.
You were driving too fast for the conditions?
Yes, sir. I'm not aware of the speed I was actually going, but I believe too fast for the conditions. That's correct.
All right. And you would admit that you were driving in a willful or wanton fashion with disregard for the safety of any other persons or property. Is that correct?
Yes, Your Honor.
All right. And on that same date, had you used fentanyl?
No, I don't believe I had use on that day.
Hey, were you in possession of fentanyl?
Yeah, I was in possession of pills, Your Honor. Yes.
You were in possession of pills?
Yes, Your Honor.
What kind of pills were you in possession of?
To my knowledge, they were Percocet.
They were Percocet? Schedule
Yes,
one.
sir.
All right. And you didn't have authority or a prescription to have those pills, did you, sir?
No, sir.
And you knew that you had them?
Yes, indeed, I did.
All right. Accepting the higher charge for the added count 4. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to counts 2 and 4. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14 probation. Sentencing in this matter will be March 13th, 2025, 10 a.m., Judge Washington.
March 13th. Okay,
Yes, sir.
one moment. March 13th at what time did you say? I apologize.
It's at 10 a.m.
10 a.m. Okay.
Yes,
Your
they'll
Honor,
have to do a writ to get you on Zoom, or get you logged in, so that date might change a little bit.
And Your Honor, if I may, I believe Mr. Kula has a number of other matters before the 14B court, and
Okay.
I did inform him that once that court knows of this sentencing, they should pull his other cases so that he can schedule and get those cleared.
Got it.
Yes,
Okay,
and
very good.
just-
Thank you.
If I could please add one thing. I know I'm in open court. I also have a charge in 15th district. Being in the FBOP, it's really hard to relay these things. So will that be addressed then as well? And the only thing secondly is, could you guys fax over to my counselor any court dates or any outcome of this, so that they're aware of what's
your counsel may be able to find other court dates.
Okay.
I don't have the 15th District Court files here.
Okay.
I will email the Bureau of Prisons, Mr. Kukola, with
Unlike other cases, here's Mr. Rudell, caught improperly transporting a firearm and now facing the consequences for failing to follow even the most basic gun laws.
Sir, can you state your name, please?
My name is Mike Rudell.
Thank you. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of improper transport of a firearm in a motor vehicle, the 90-day offense. Upon his successful plea to that charge, count one would be dismissed. That is the court's full understanding of the agreement.
That is correct, Your Honor.
That is correct, Your Honor.
Has he signed in? He has. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Mike Rudell.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of improper transport of a firearm in a motor vehicle. That's a misdemeanor punishable by up to 90 days incarceration, a $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour, 1484 District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're guilty of this case, of
Yes,
this
sir.
offense? All right. September 1st, 2023, at the location of West Main Street near Washington Street in the city of Manchester, Washtenaw County, state of Michigan. Were you in a motor vehicle?
Yes.
Did you have a weapon or firearm in that vehicle?
Yes, sir.
Where was it located?
And center console in a case.
All right. And you did not have the authority to transport that weapon in that fashion, is that correct?
No, sir. I had an expired CPL.
Pardon?
I had an expired CPL.
Got it. So you did not have authority to
Correct.
transport in that fashion. Counsel, have its court complied with the court rule, and would it be proper to accept this defendant?
The people are satisfied.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be April 15, 2025, 9 a.m. before Judge Freshour. Bond in this case will continue. Thank you, sir.
Finally, these last two cases center on Ms. Stephanie facing charges for being in possession of hard drugs to Mr. Ashley, whose case keeps getting delayed while negotiations drag on.
That's correct, Your Honor.
Very good. Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name for the record.
Stephanie Joy Woodall.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
I understand that.
All right. And understanding that, you still wish to plead guilty?
I do wish to plead guilty.
All right. I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I understand.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I understand.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or remain silent and not have that silence used against you, and giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that?
I understand.
You understand you're giving up your right to appeal of right?
I understand.
Are you on probation or parole? You are not,
I am not.
correct? Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to flee?
No,
Anybody threatened you or coerced you?
no.
You're doing this voluntarily
I am doing it voluntarily.
and of your own free will,
Yes,
and because you believe that you're guilty?
yes,
April 12, 2023, at the location of 3025 Michigan Avenue, East Michigan Avenue in Ypsilanti Township, Washtenaw County, State of Michigan. Did you have fentanyl in your possession?
I did.
Had you used it?
Yes,
And did you know what you were using was fentanyl?
yes,
Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
The people are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be March 13, 2025, 10 a.m. Judge Washington. Bond will continue. Thank you.
Thank you, Your
thank
Honor.
you.
Ms. Woodall.
Court does call the case of the people versus Jerry Ashley.
Andrew Childers appearing on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Chinazi Carey, I can really on behalf of Mr. Jerry Ashley. Mr. Ashley, state your name for the record, please.
Jerry Ashley.
Thank you.
Your Honor, if I could just speak to my client very briefly. Mr. Ashley, we're going to adjourn today. The prosecutor and I are still working on a negotiation, okay?
Okay.
So, Your Honor, we'd be requesting an adjournment.
Probable cause conference without objection will be adjourned March 6, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Ashley.